Good afternoon. Can I welcome you to Greenway Chambers for the continuation of the CPD Super Series. For those who don't know me, I'm Edward Cox, one of the other barristers here, but I'll give a short introduction to our two speakers. It is, I think, the 10th year that we have been running this series, and reminded me that Dinesh Ratnam was then starting on this for 10 years ago, so it seems appropriate that in the anniversary month we have Dinesh speaking on this subject. Dinesh, for those of you who don't know him, came to the bar in 2015. He's a commercial and equity barrister with a practice from broad commercial and equity work through to insolvency, company matters and building and construction. He can be regularly seen appearing in the commercial list of the Supreme Court and in the Federal Court, which makes him ideally placed to speak about the subject this evening. And our second presenter is Andrew Girgis, who came to the bar in 2021, having previously been a solicitor at CBP as a senior associate from 2015. He has appeared in a broad range of commercial matters, not just in the consumer and space, but also through to building and construction. A review of his details showed, at least to me, that he's much more qualified, educated than I am, so hopefully he can illuminate to all of us what glorified but-for causation might mean, which is how I understand the topic. Dinesh, I think you'll first.
Well, I'd like to welcome you all back to Greenway Chambers. It's been a while since we've had physical attendances since COVID. I'll be reporting back to the board that the threat of not live streaming today has forced you all back here, so that's a good thing. Now, we appreciate you all have busy practices, so it's a pleasure to see you in the house. I'm expecting that at least 45% of you are here for the canapes and 10% of you are here to work out whether or not there's an after party. I can reliably tell you that 45% of you will be pleased. Andrew and I decided to present on the topic of counterfactuals because there seems to be a resurrection and divergence of views recently regarding pleading counterfactuals. Some recent guidance arises out of Queensland, which I'll speak to. Although our topic focuses on misleading and deceptive conduct, the position equally applies in relation to tortious claims. I'm going to speak more generally in terms about counterfactual by reference to some cases. Andrew is going to speak to you about whether or not you should plead counterfactuals and how you should do it and why. Hopefully this presentation will give you some guidance in taking instructions from your clients before preparation of evidence and well before you start pleading your respective cases, whether it be for the plaintiff or defendant. No doubt what we will tell you will impact advice on prospects, but also relevantly focus attention on the type of damages, whether it be you acting for the plaintiff or the defendant. Now, before coming to the role of counterfactuals in misleading and deceptive conduct cases, we need to start with the topic of causation. A plaintiff which seeks a Section 236(1) award for damages under the ACL must demonstrate to the court the existence of a sufficient causal link between the misleading or deceptive conduct of the defendant and the loss and damage which it alleges that it suffered. Such a statutory term enhances what the common law would embrace as issues of causation, remoteness, and measure of damages. The statute's requirement to demonstrate a causal connection between the contravening conduct and the alleged loss of or damage informs an order of the compensation. When lawyers use the term causation, one of two inquiries may be involved. The first concerns the role of a defendant's breach of contract, negligence, or contravention played, along with other conditions or causes in bringing about the loss. It concerns factual concerns and causes. The second inquires whether legal responsibility should be attributed to the defendant for such a loss. It proceeds on the basis of an understanding of factual causes. The scope of responsibility inquiry is whether to attribute legal responsibility for an occurrence, namely a loss, for which the defendant's conduct was a cause. The claimant need not prove that the contravening conduct was the sole cause of the claimed loss or damage. It is sufficient if it was the cause of the loss in the sense of materially contributing to it. The relevant factual inquiry is whether the particular contravention caused or materially contributed to the loss. Material contribution requires only that the defendant's act or omission played some part in contributing to the loss. Now, simply put, loss or damage may be the result of contravening conduct even though other factors contributed to its occurrence. In a case which the claimed loss arises from the claimant's entry into the transaction, a claimant may seek to prove that if aware of the true position, it would not have entered into the transaction, but would have entered into a different transaction or no transaction at all. The label no transaction may be used to describe a case where the claimant asserts that it would not have entered into the transaction and so should be compensated so as to restore it to the position that it would have existed if there had been no transaction. The label different transaction describes a case in which the claimant asserts that it would have acted differently if the true position had been revealed. The claimant does not seek to be restored to its original position, but to a hypothetical one based on postulated differences. The label no transaction has the potential to mislead because it may be used simply to describe a case where, absent the breach, the transaction which actually happened would not have happened. In such a no transaction case, the claimant is not necessarily required to identify alternative transactions and address what alternative transaction would or would not have been entered into. In Westpac Banking Corporation v. Jamieson, it was stated there, it may be sufficient for the plaintiff to simply prove that he or she would not have entered into the subject transaction. Policy or pragmatic considerations suggest that a plaintiff should not necessarily be required to prove what else he or she should have done. A requirement for such proof increases the complexity and the cost of litigation by exploring alternative transactions, including investments which are not seriously considered. Converse to a no transaction case, the position may be different in a case in which it is apparent that, absent the breach of duty or other contravening conduct, the claimant would have entered into a different transaction, either with the defendant or another company or party. In Jamieson, Justice Applegarth gave the example of a plaintiff who was induced to buy shares in Company A and, absent the negligent advice, would have bought shares in Company B. By that example, Justice Applegarth observed, it is hard to see why, in point of principle, a court, in assessing the appropriate measure of compensation for loss caused by the negligent and misleading advice, should be required to ignore the fact that, absent the negligent advice about Company A, the plaintiff would have bought shares in Company B and suffered loss on that investment in a declining share market. Proof of factual causation in a case about commercial transactions typically involves the claimant proving that, but for the contravention, it would not have entered into the loss-making transaction. The but-for test may not be an exclusive or exhaustive test of factual causation, as some of you know. One of the leading High Court authorities relevant to today's topic is Berry v. CCL Secure. It was said there that a plaintiff must plead all material facts to constitute the cause of action, including any counterfactual on which the plaintiff relies to establish the requisite causal link between the identified loss or damage and the cause of action. Now, where causation is essential to a pleaded action, the following is necessary to have regard to. Justice McHugh in Henville and Walker said, if the defendant's breach has materially contributed to the loss or damage it suffered, it will be regarded as a cause of the loss or damage, despite other factors or conditions having played an even more significant role in producing the loss or damage. His Honour was stating there that as long as the breach materially contributed to the damage, a causal connection will ordinarily exist, even though the breach without more would not have brought about the damage. There are some exceptional circumstances or cases where abnormal events intervene between the breach and the damage. It might be right as a matter of common sense to hold that the breach was not the cause of damage, but such cases are exceptional. In Sedgwick versus JLOC, it was said, the pleader must plead the material facts which establish the necessary causal link between the alleged wrongful conduct and the claim loss. That duty extends to require the pleader to plead the material facts on which the party relies to establish any counterfactual relied on to establish the requisite causal link. The pleading so framed must give rise to a reasonable inference that the alleged wrong conduct and the claim loss stand to each other in relation of cause and effect. The entitlement to have the foregoing matters pleaded should be regarded as an incident of the essential function of pleadings, which is to ensure the basic requirement of procedural fairness, that a party should have the opportunity to meet the case put against it. It was observed by Justice Jackson in Graham and Linda, yes, a Queensland case, but some useful guidance comes out of this if you are pleading in Queensland. You need to plead that the loss suffered is a loss of a valuable commercial opportunity, identifying the opportunity with some particularity. You need to plead what the plaintiff would have done, where what the plaintiff would have done if the defendant had not been in breach of duty is a necessary causal condition to deciding factual causation. You have to also plead the percentage or proportion of the opportunity that was lost, and that appears to be something that they do in Queensland more often. And where the lost opportunity pleaded is 100%, it is expected that the plaintiff will allege with some particularity the facts by which that certain outcome would have been achieved. I'll return to the last 2 points shortly, but interrupting the point conveniently to look at some useful forms of loss. In the case of tort, damages is the sum of money which will put the party who has been injured or who has suffered in the same position as he or she would have been in had he or she not sustained the wrong for which he or she now is getting their compensation or reparation. In contract, the rule of common law is that where a party sustains a loss by reason of a breach of contract, he is, so far as money can do it, to be placed in the same position or situation with respect to damages as if the contract had been performed. In equity, compensation is assessed at the figure then necessary to put the trust estate or beneficiary back into the position it would have been in had there been no breach. There's a distinction between fact of loss and the value of loss. A claim for loss of an opportunity represents a claim for the value of an opportunity to receive an expected benefit. It is not a claim for the value of the expected benefit itself. The opportunity to receive an expected benefit is the probability that the benefit would accrue in the manner expected. Returning back to Justice Jackson's 4 points in Graham and Linda, His Honour illuminated 2 further points. In a number of recent cases, courts have considered the context of the proof and pleading required by way of causation and loss, where a plaintiff alleges that as a result of the defendant's breach of contract, negligence or misleading conduct, the plaintiff would not have entered into the actual transaction that was entered into. where the plaintiff alleges that they would have entered into no transaction on one hand or a different transaction on the other hand, the pleading should clearly allege the counterfactual scenario. In similar vein, Justice Jackson took the view that where a plaintiff alleges loss of a valuable commercial opportunity, the plaintiff should in most cases also allege the extent of the loss it says it suffered on the possibilities. His Honour said it was not sufficient for a plaintiff to simply allege 100% possibility of obtaining the hoped for or expected benefit, leaving it open to contend that the issue to be decided by the court is the actual degree of likelihood, anywhere between 100% and 1%. What His Honour was saying here was the plaintiff needed to formulate its case with all reasonable precision in the aid of procedural fairness. Now, as recent as 2023, there's been some judicial consideration in relation to Justice Jackson's remarks. Justice Lee and Justice Jackman weighed into the debate at appellate level in Land Track Holdings Pty Limited versus Yameen. Both justices took the approach that Jackson J's approach might be a little too strict. Justice Lee in Landtrack cited his own observations in Lloyd and Bell Conan, Lakeview Pty Limited in 2019 FCA 2177. His Honour confirmed it is necessary in a loss of opportunity case to specify the relevant opportunity, the material facts relied upon, and the amount of damages claimed. Usually and ideally, this is done by a proper pleading of the type identified by Jackson J in Graham, but at the very least it is necessary to appraise the party meeting a loss of opportunity case of the case being run at the commencement of the case and the material facts relied upon in a way sufficient to afford some form of procedural fairness. Jackman J similarly said that Jackson J's approach represents a counsel of perfection and would not usually need to be followed to the letter in order to ensure procedural fairness. Noting, and not unsurprisingly, His Honour remarked, and I'm sure we would all well embrace, in an ideal world, at the time of pleading, one may not have all discovered material and expert evidence may not have been commissioned so early. Jackman J went on to say that in the typical case, procedural fairness is met by compliance in the pleading with the first two of Justice Jackson's four requirements, and the other elements of a case based on loss of valuable commercial opportunity can then be amplified in the claimant's opening, evidence and closing submissions. If you needed further affirmation, Justice Derrington agreed with all of that in mining standards in the federal court. And so what those observations and remarks tell you is it is sufficient in pleading of a lost valuable commercial opportunity for the plaintiff to plead that the loss that it has suffered is of valuable commercial opportunity and identifying the opportunity with some precision. It follows that the plaintiff must plead what it would have done what the plaintiff would have done if the defendant had not been in breach of duty, this being a necessary causal condition to deciding factual causation. Unhappy customer. Although it might be useful for a plaintiff to provide an indication of the degree of likelihood of the relevant steps being pursued to fruition, that can be difficult to predict to any degree of certainty in a pleading. In other words, it could amount to no more than an educated guess, which we recognise as lawyers as speculation, and this should be avoided. Now let's look to the statutory framework. The law draws a distinction between cases of mere difficulty in proving damages, which must often be assessed on a counterfactual basis, and cases where damages are refused because the position is too speculative. In such cases, it is important to have regard to the capacity of the plaintiff to adduce evidence and how truly speculative the loss is. Right, that didn't come up. What I wanted up was section 18 and 236, but I'm sure you all read it. Now, Section 18 of the ACL applies in relation to a very broad range of economic activity. Section 236(1) contains no limitation on the kinds of losses or types of losses and damage to which it applies. It does not indicate that a commensable loss or damage must have been suffered by the plaintiff in any particular manner, and provides no guidance as to what measure of loss and damage is intended. Hence, applicable principles have emerged and evolved somewhat on a case-by-case basis. The damages provision, 236(1), reinforces Section 18, sub 1, by putting persons who engage in trade or commerce on notice that there could be pecuniary consequences to them if the statutory norm is not adhered to. An award of 236(1) damages operates to ameliorate the adverse consequences of conduct in breach for a person who suffers loss and damage caused by that. The object of an award of damages here is to restore the plaintiff to the position that it would have been in had the contravening conduct by the defendant not occurred. That is to say, to compensate the plaintiff in respect of the loss and damage which the defendant's conduct caused it. Some principles. Let's dive into the principles. Some of you will be across this. The question of whether conduct is misleading or deceptive or likely to mislead or deceive is determined by looking at the relevant course of conduct as a whole in light of the surrounding facts and circumstances. Contravention of the statutory prohibition requires proof that the relevant conduct is misleading or likely to mislead or deceive. Whether the conduct is misleading or likely to mislead is an objective question. A person may be misled by information or a document that is neither misleading nor likely to mislead. For example, a person did not read something, or that person misinterpreted what is said or written. A more direct example would take place in the Ratnam household, that's my household, where my wife leaves notes for me to undertake certain housework chores. When I don't do it because of what I might respectfully say in my learned and legal opinion, the note contains a number of misleading statements created by the author. A debate ensues about misrepresentation, whether the note really meant if I had to undertake the work immediately or next week, and if I didn't undertake those works, whether there would be repercussions. Now, I digress, but just in case if you wanted to know, bold letters and uppercase means do it now. If, however, a contravention is proven because conduct is likely to mislead, the contravention will not be productive of loss if the claimant is not misled, or having been misled, ascertains the truth before it is too late and ceases to be misled before the loss is suffered. A claimant who is misled by conduct that is misleading or likely to mislead does not cease to have a claim simply because it would not have been misled if something more had been done, such as making further inquiries or analysing information that was in its possession. In some cases, an egregious failure by a claimant to make inquiries or take steps that easily would have revealed the misleading nature of a representation may be relevant to a causation issue. However, the starting point is that misleading conduct does not cease to be misleading and to cause loss because of an unforeseeable or unreasonable failure by a claimant to make inquiries or take steps that would have resulted in it not being misled. A failure to take reasonable care may be relevant to a reduction in compensation under 137(b) of the Competition and Consumer Act. In a simple case in which a claimant alleges that it suffered loss by reason of, or because of a misleading representation that induced it to enter into a loss-making transaction, a factual issue is whether the claimant relied on the representation in entering into the contract. A different factual causation issue arises if the claimant argues that the contract, and therefore the claim loss, would have not occurred had the misleading representation not been made. This concerns proof of past hypothetical fact, the probable course of events if the misleading conduct had not occurred. The reliance issue in such a simple case is whether the relevant representation induced the claimant to enter into the contract, which in turn caused the claimant to suffer loss. The reliance issue is determined by the application of general principles. It is sufficient if the claimant relied upon the misleading representation. That reliance need only be one of a number of factors that caused the claimant to enter into the contract. The fact that the claimant relied upon other matters, such as its own inquiries, does not mean that it did not also rely on the misleading representation. In other words, it is sufficient if the misleading conduct in making the pre-contractual representation was a cause of entry into a loss-making contract. But as we know, reliance is not essential, causation is. The claimant's counterfactual depends on circumstances of the case, including its pleading. In some cases, the counterfactual simply may be the hypothetical situation had a statement not been made. In other cases, the relevant inquiry is what probably would have occurred if, instead of omitting to disclose something, there had been disclosure. For example, a counterfactual may be what would have occurred if the truth had been disclosed so as to correct an earlier statement that had ceased to be accurate and therefore misled the party to whom an obligation of disclosure was owed in the circumstances. The claimant must prove the contravention caused the claim loss, typically doing so by satisfying the but-for test. The claim loss is alleged by the claimant, and to recover that loss, it must prove what it would have done in the absence of the contravening conduct. The legal onus on the claimant is constant. It may be unhelpful to speak of an evidentiary onus shifting to the defendant. The cases, however, recognise that an evidentiary burden may shift where the claimant discharges its level of onus by direct evidence or proof by inferences drawn from the whole of the evidence. Jamieson stands for the proposition that a claimant is required to prove that it would not have entered into the subject transaction. It is not necessarily required to prove what else it would have done. A claimant may choose to prove what else it would have done, for example, by proving that instead of entering into the loss-making transaction, it would have entered into an alternative profit-making transaction, or at least that it lost the opportunity to pursue a valuable commercial opportunity. Depending on the circumstances, the claimant's case may be that instead of making the loss which the contravening conduct caused it to suffer, it would have entered into a different transaction and suffered a much smaller loss. In such a case, the measure of its damages is likely to be the difference between the actual loss and the hypothetical smaller loss. Jamieson also recognised that in principle it is open, and I emphasise, open to the defendant to allege that instead of entering into the subject loss-making transaction, the claimant would have entered into a different loss-making transaction. There is authority, Weisenbeek v. Australian Maritime Imports, 2019 FCAFC 167, that stands somewhat separate to that analysis. Weisenbeek stands for the proposition that proof of loss requires an evaluation of the chance that the claimant would have entered into a different hypothetical transaction and suffered loss. Weisenbeek did consider Jamieson. Justice Abelgarth, who sat in Jamieson, considered Weisenbeek in Davis and another versus Perry O'Brien Engineering 2023 QSC 243. Justice Abelgarth was critical of Weisenbeek's approach, stating that it misunderstood or misstated what was said in Jamieson. Justice Abelgarth stated that Jamieson did not stand for the proposition that proof of loss requires an evaluation of the chance that the claimant would have entered into a different hypothetical transaction and suffered loss. Jamieson did not encourage speculation about whether the claimant would have done something else. Jamieson and other authorities do, however, envisage circumstances in which it will be appropriate to depart from the general rule, that is, it is relevant to inquire into what other transactions the party would have entered into if it had not entered the subject transaction. One such circumstance is where the issue is raised by one or another of the parties. Another is where the claimant's case that the subject transaction would not have been entered into in the absence of the contravening conduct raises the issue of whether a different transaction or transactions would have been entered into. The hypothetical in Jamieson of a claimant being induced to buy shares in Company A rather than shares in Company B is an example. Weisenbeek concluded that the statutory purpose of compensating a person who has suffered loss by contravening conduct could hardly be served if the contravener could say that despite the contravention, the claimant is really no worse off because it would have suffered the same loss as that suffered by the misleading conduct in some other transaction that did not eventuate. Justice Applegarth disagreed with that view in Davies and Perry, taking the view that in a typical case, the statutory purpose of compensation is hardly served by awarding compensation for a loss that would have been suffered in any event and in the absence of the contravening conduct. There may be atypical cases in which the but-for test of factual causation is not appropriate. In cases in which a claimant accepts that it must prove that absent the contravening conduct, it would not have entered into or proceeded with the loss-making transaction, or where this but-for test falls to be applied, proof of causation may permit or require inquiry into a different hypothetical transaction. This may be the case where alternative transaction would have produced a loss. To ignore or preclude such a likely alternative transaction would not aid the statutory purpose of compensation. It would result in the claimant being overly compensated for a loss it would have suffered in the absence of a contravening conduct. In Weisenbeek, the court stated that the relevant statutory provision governed the award of compensation permits the recovery of the whole of the loss or damage suffered by a person who establishes that a contravention was a cause of loss or damage. It cited Henville in that regard. And Henville, of course, was a case in which the claimant established that but for the contravening conduct, the claim loss would not have occurred. It did not address a situation in which the claimant is unable to prove that it would not have suffered the claim loss in the absence of the contravening conduct because the evidence shows that it would have entered into a different loss-making transaction. Jamieson addresses that circumstance. There does not seem to be any strong authority to suggest that it is irrelevant to inquire into what the claimant would have done had the defendant not engaged in the contravening conduct. I don't think that necessarily will be the approach likely to be taken by courts, and certainly in Davies and Perry, that approach was not taken. Now, such an unqualified rule is contrary to principle of compensation and authorities about proof of the causal connection between the contravening conduct and the claim loss. This includes the High Court's consideration in Berry of the probable course of events, if assuming counterfactually Dr. Berry had not been tricked into signing the termination letter, proof the claim loss depended on both the period of the agreement that it would have continued under and the commissions that would have been payable under it for as long as it did. Any concerns as to whether it is irrelevant to inquire into what the claimant would have done had the contravening conduct not occurred would be inconsistent with decisions here in New South Wales. I'm referring to the Court of Appeal decision in DSHE Holdings Limited v Potts 2022 405 ALR 70. In that case, it was not irrelevant to inquire what the claimant financier would have done in those circumstances in terms of lending in respect of its relationship with its client where it found out about its true financial position. Touching upon the importance of pleading counterfactuals, in Davis, Justice Applegarth remarked on the importance of pleading counterfactuals by reference to Weisenbeek's special leave application. Justice Applegarth stated, "The High Court did not dismiss the application for special leave on the basis that the proposed appeal had insufficient prospects of success, as the respondent to that application argued." NettleJ concluded, despite the question of principle identified by the applicant as to whether it is open as a matter of law to assess damages for misleading and deceptive conduct by reference to a pleaded and proved counterfactual, the court is not persuaded that the pleadings and the evidence below are such as to render this an appropriate vehicle for the grant of special leave. In Weisenbeek, the defendants had not pleaded a counterfactual, therefore the application was an inappropriate vehicle for the principle that a defendant can plead and prove a counterfactual that shows that the claimant would have suffered the same or some other loss had the defendant not engaged in the contravening conduct. Finally, some passages in Weisenbeek are to the effect that a defendant may not raise a counterfactual and seek to demonstrate that the claimant probably would have suffered a loss from entering into the alternative transaction. Such a view is at odds with the principles of causation and compensation applied by the High Court in Berry. Berry stands for the proposition that even a fraudster may plead and prove a counterfactual. The same rule applied to contravening conduct. This accords with the general principle that a wrongdoer is not required to compensate a victim for loss which the wrongdoer does not cause, even when the cause of action is the tort of deceit. Berry is the authority that stands for the proposition that a defendant may plead a counterfactual about what would have happened if the contravening conduct not occurred. So returning back to Berry, a plaintiff should be expected to plead all material facts on which the plaintiff relies to constitute the statutory cause of action, including any counterfactual on which the plaintiff relies to establish the requisite causal link between the identified loss or damage and identified misleading or deceptive conduct. In the same way, a defendant resisting the statutory action should be expected to plead any different counterfactual on which that party might rely to deny the causal link, unless and to the extent that the parties choose to depart from the pleadings in the way they go on to conduct the trial. Choice between the competing pleaded counterfactuals on the balance of probabilities should then exhaust the fact-finding that is required to be undertaken by the court on the issue of causation. In DSHE, Justices Leeming and Kirk and Baston stated that there is no rule of law that requires the approach proposed by Justices Gagler and Edelman to be adopted in every case of misleading and deceptive conduct. No such obligation was said to be found in the joint decisions of Justices Bell, Keane and Nettle in Berry, and nothing in the reasons of Gagler and Edelman was said to lend support of the proposition they were enunciating a fixed rule to be applied invariably. In DSHE, the relevant circumstances, including the attitude of the claimant when it was confronted with information about the financial position of its customer, was examined in detail at trial. This permitted the trial judge to conclude that based on the objective evidence, including what the claimant actually did when it learned the truth of its client's financial position, it would not have walked away from providing additional funding to it. The best evidence of what would have happened had the claimant not been misled was what actually happened after it was told the truth. The claimant failed to explain why it would not have advanced money on such terms or some terms if it had known the true position. The trial judge's inquiries into the counterfactual was not inverting the onus or subverting the beneficial purposes of the statutory prohibitions against misleading and deceptive conduct. In fact, the decision did not turn on any pleaded or articulated case advanced by the claimant. A court can speculate about what the claimant might have done and to award compensation based on an evaluation of a chance that the claimant may have engaged in some other hypothetical transaction. That really only arises on the objective facts, where the parties each know the facts and there can hardly be any suggestion or grievances that they weren't on notice of the possibility of such a hypothetical. Obviously, it is the judge's role to fairly award compensation. The court can speculate on a hypothetical pleaded by the defendant, unless the defendant can demonstrate with a reasonable degree of certainty, therefore, both the fact that the claimant would probably have suffered a loss from entering into an alternative transaction and the amount of that loss, the damages will not be reduced by any amount. Justice Applegarth has suggested that a defendant wishing to invoke the principle stated in Jamieson in a case in which it is applicable should plead the counterfactual on which it relies to deny the causal connection pleaded by the claimant. The position may be different where the way they conduct their trial is clear that the parties depart from the pleadings and their competing counterfactuals are apparent and explored in evidence. Any other course has the potential to undermine the purpose of pleadings, which is to ensure the basic requirement of procedural fairness that a party should have the opportunity of meeting the case against him or her, and to define the issues for the decision. The statement from Justice Applegarth reinforces the approach taken by the child judge in DSHE. Not defining the issues by pleadings encourages parties to invite findings of fact based on speculative hypotheses that are not explored in evidence. An inference that the claimant would have entered into a different transaction to the subject transaction in the absence of the contravening conduct should not be based on speculation or inadequate foundation in proven facts. The different transaction should be defined in the pleadings. If the defendant contends that such a different transaction would have been entered, it should plead it. This is a basic requirement of fairness, procedural fairness, so that the claimant has the opportunity of meeting the case and discharging the onus of proving that the contravention caused the loss or damage it claims. If the claimant's case that absent the contravening conduct it would not have entered into or proceeded with the relevant transaction is proven on the balance of probabilities by reference to objective factors and proof by inferences drawn from the whole of the evidence, then it will discharge its onus of proof on causation. Its claim is not defeated by conjecture or speculation that it may have entered into an alternative transaction. The parties' competing hypothesis or counterfactuals, like any other conclusion, depend on inferences drawn from reliable evidence that is accepted. The court must be satisfied that the evidence enables it to draw a reasonable and definite inference from circumstances. The inferences urged by the claimant that it would not have entered into or proceeded with the relevant transaction in the absence of the contravening conduct must be more probable than not. Any competing hypothesis that the claimant would have completed the transaction or would have entered a different transaction that resulted in its suffering loss must also be a reasonable inference rather than mere conjecture, guesswork or surmise. To adopt what was said in Jamieson, unless the defendant can demonstrate with a reasonable degree of certainty both the fact that the claimant would probably have suffered a loss from entering into an alternative transaction and the amount of that loss, the damages will not be reduced. This is not to reverse the legal onus of proof on causation, which remains on the claimant. It simply recognises that proof of causation based on all the evidence does not require the claimant to exclude unproven competing hypothesis. In such a case, the defendant has the so-called evidentiary onus or practical burden to adduce evidence in circumstances in which the claimant will have otherwise discharged the legal onus of proof. Now, before I hand you over to Andrew, just let me speak to you briefly about the recent High Court case delivered in November last year. It's a negligence case, but I expected some of you who spend their weekends reading these authorities may be troubled if I didn't mention it, but I'll do it only in brief. At trial, Mr. Daly contended his former lawyers negligently advised him in relation to a binding financial agreement. He argued he was worse off by the financial agreement because his lawyers did not advise him on what could be described as a foreseeable future event in a partnership. Those future events came to fruition, which included Mr. and Mrs. Daly having children. The financial agreement did not properly take into account when it was enforced in relation to the children. Mr. Daly said he suffered a loss. Mr. Daly attempted to argue at first instance and on appeal there were a range of hypotheticals which were not properly articulated, evidenced or proved. It was said in the High Court by Justice Gageler, Jago and Beach-Jones that Mr. Daly's claim was bound to fail because Mr. Daly failed to adduce evidence establishing the fact of loss, that is, as to the form of the financial agreement that a lawyer in 2005 exercising reasonable care and skill would have drafted to avoid it from being set aside. Their Honours observed that even if Mr. Daly suffered loss as a consequence of his previous lawyer's failure to exercise reasonable care and skill would not have required the precise terms of the counterfactual financial agreement to have been identified, he did not identify the scope, nature and likely monetary amount or range of amounts that provision for a scenario involving children. Mr. Daly was at least required to lead evidence as to the kind of financial agreement he would have entered into to permit an assessment of whether Mrs. Daly would have agreed to it and whether it would have survived a challenge some years later. Mr. Daly did not come to proof on loss because no assessment could be made by the court on his counterfactual case. So their Honour's observations illustrate the care that needs to be taken, not only in identifying the relevant counterfactual, but by proving it. I'll hand you over to Andrew.
Thank you, Dinesh. I should probably begin by making an admission of my own, which is that I'm probably guilty a bit of misleading deceptive conduct, because although the title of tonight's topic suggests that we'd only be speaking about misleading or deceptive conduct and counterfactuals in that context, I will be touching on negligence. As you'll hopefully come to see, the two are very much interrelated when it comes to causation. So just to recap with some general pleading principles, the basal function of pleading the relevant counterfactual achieves at least two things. Firstly, it forces the pleader to engage with two key elements of the relevant cause of action, that is causation and loss and damage. Secondly, it's a necessary incident of the essential function of pleading, that is, to enable the defendant to understand the case put against it. And you'll see there in the passage from Berry that you've already been taken to, that Justices Gagler, Edelman, and Edelman have emphasised this, the importance of this rather. And many Supreme Court and appellate courts across the country have also acknowledged this. I've included some observations from Justice Davies just as an example. And both of those relate to misleading and deceptive conduct claims. Now, in terms of negligence, the same holds true, and that is so whether one is pleading negligence as a consequence of a breach of a statutory duty, for example, Section 37 of the Design and Building Practitioners Act 2020, or at common law. One sometimes sees a pleading which boldly asserts that a defendant has breached the duty of care or contravened a relevant section of the ACL in relation to misleading or deceptive conduct, followed by a bare assertion that the plaintiff has suffered loss and damage. A pleading of that kind is liable to be struck out. In a negligence claim, it's also important to keep at the forefront of one's mind Section 5D1, which often gets overlooked, but the authorities in this state, and some from the High Court, certainly emphasise the need to frame one's case by reference to Section 5D1. And you'll see there's the decision from Justice Ratnam, which essentially ties those two aspects together. And similarly, the decision from Parkview, Justice Stephen in Parkview, that's a comment made in the context of Design and Building Practitioners Act. It's useful to just recap on some of the terminology that Dinesh has already touched on. So a no transaction case is essentially where a plaintiff asserts it would not have entered into a transaction at all had the truth been known or had some negligence not occurred. For example, a plaintiff might say, I would have never purchased that property if I had not been told X. An alternative or a different transaction case is a little bit trickier. It can be asserted by either a plaintiff or a defendant in different ways. When it's asserted by a plaintiff, the plaintiff is usually saying one of two things. The plaintiff is usually saying, but for the relevant misrepresentation or wrongful conduct, I would have entered into the same transaction, albeit on different terms. For example, the plaintiff might say, I still would have purchased that property, but I would have paid less. Alternatively, but for the relevant representation, I would have entered into a different transaction altogether. For example, instead of investing the same amount of money in a particular property, the money would have been invested in a different transaction elsewhere, which would have allegedly yielded some benefit. But when it's asserted by a defendant, it's usually done so to establish that no loss has arisen. For example, a defendant would seek to prove that the plaintiff would have in any event entered into a different transaction under which it would have suffered a loss. So the relevant point being made here is the mere fact that there is misleading conduct or negligence does not always convert into a loss. That is an element which must be established separately. These kinds of alternate or different transactions have been described by Justice Brereton, with whom Chief Justice Bell agreed, as speculative and hypothetical in Mills and Walsh 2022 NSWCA 255 at paragraph 115. Now, just to confuse things slightly, it's also been recognised that there's no strict requirement to actually establish a counterfactual case as a gateway to damage. That is, not every case will necessarily lend itself to a counterfactual analysis. It's not easy to really think about what sorts of cases could fall into that particular scenario, but in Our Lawyers and Mr. Daly, to which Dinesh has already referred to just at the end of his presentation just then, Chief Justices Gagler and Justices Jago and Beach-Jones stated at 49 that in some lawyer negligence cases, a court can infer the particular steps that might have been taken had the lawyer discharged their duty. However, as the authorities in the slide before you recognize, counterfactuals are a useful tool to assist in establish causation and loss. And one can plead many counterfactuals if desired, but it's not necessary to do so. In terms of pleading the counterfactual, a good rule of thumb is to adopt the but-for test. The but-for test is inherent in the counterfactual analysis. It's useful to ask, was the wrongful act, i.e. the misleading conduct or the negligence, necessary for the loss? And as Justice Edelman explained in Lewis and Australian Capital Territory, 2020 HCA 26, just in the slide there at paragraph 178, the test for causation of loss asks whether the wrongful act was necessary for the loss. The but-for or counterfactual approach directs us to change one thing at a time and see if the outcome changes. The change is the removal of the wrongful act. If the loss would lawfully have occurred but for the wrongful act, then the wrongful act was not necessary for the loss. The counterfactual approach thus involves a hypothetical question where no other fact or circumstance is changed other than those which constituted the wrongful act. Ultimately, another way of testing the position is to simply ask whether the plaintiff relied upon the wrongful conduct. Now, some example cases. Negligence. Helpfully, some general guidance has been provided by the presidents of the Courts of Appeal in Victoria and New South Wales. So, in Finley and Victoria, 2009 via CA 294, President Maxwell stated at 2. I won't read it out, but it's a very useful it's a very useful explanation of what needs to be pleaded and ultimately proved in a negligence case. And more often than not, that same sort of analysis can be adopted in a misleading or deceptive conduct case, particularly where there is where the alleged misrepresentation or loss arises from a transaction that's been entered into. In Serijenko and AXL Financial Proprietary Limited 2019 and SWSC 1610 at 52, the Chief Judge Ward in equity, as the president then was, stated, the failure of the pleading to identify the risk of harm and the reasonable precautions against that risk is said were required gives rise to difficulties in relation to the case on factual causation under Section 5D1A. What the plaintiff must do is identify the likely credible sequence of events which would have occurred but for the breach. And I should just indicate, although it's not on the slide, that same analysis has been picked up in the context of Design and Building Practitioner Act pleadings by Justice Stevenson and Ball, as his honour then was, over the last 2 or 3 years. The issue is sometimes straightforward, where the counterfactual is premised on a no transaction case. There's usually little difficulty in pleading and sometimes proving that kind of case. But where you're dealing with misleading deceptive conduct or negligence cases which involve a different transaction case, then the exercise, I think, is much harder, particularly where the fate of the different transaction rests on matters not strictly within your client's control. In other words, as Justice Stevenson observed there in Bullos Constructions, it's really one thing to say that a plaintiff would simply not have entered into a relevant transaction. That's a no transaction case. But it's an entire thing altogether to say that a plaintiff and another person would have entered into a different transaction. Questions? Counterpace?
You said you shouldn't run multiple counterfactual scenarios.
Well, I don't think I said you shouldn't do it. I said you don't have to do it. And the reason being is because it's strictly not required. So you might have a case where there might be multiple counterfactuals, but with every counterfactual that you plead, you must ultimately prove. So you could be making the task a lot harder for yourself by setting up more than one when really only one would do. Any other questions? No? All right. Thank you very much for joining us. Bye.